This is Erica Marilyn. I am the founder of Perfect Legal Video. I am very excited because it is the last interview of the day on a Friday afternoon, and it is always the most exciting. We have with us today attorney Brian Jones, and today we're going to be talking about motions to suppress. Welcome, and thank you so much for joining us this afternoon.
Hi, Erica.
How's it going today?
Great. Thanks for having me.
You're welcome. So we're talking about motions to suppress, and I guess let's just talk about what is a motion to suppress first, and then we'll talk about the nitty-gritty of like why you need it and what would happen for you to have those.
Sure. So whenever we ask the court to do anything, we do it through a filing called a motion. And a motion to suppress is shorthand for a motion to suppress evidence. And that evidence can be anything from field sobriety tests. We've talked a lot about OVIs during this month. It can be a motion to suppress items that are illegally seized. It can be a motion to suppress statements. Really anything that we want to keep out of trial because the government has violated the Constitution, or in some cases violated statutory law. We file a motion to suppress, and that's the written request to exclude that information.
So that's what you need to do. It is you need a written request. Is there anything else that you need to get a motion to suppress?
Well, you have to review the discovery because your attorney has to have a factual basis to justify filing the motion. And then after the motion is filed, so long as there's sufficient legal and factual support for the request, the court will schedule a hearing on it. And that hearing is kind of like a mini trial. The government will have to put on witnesses and present evidence to the judge in their attempt to show that they did not violate the Constitution and they did not violate statutory law in seizing evidence or gathering statements.
Well, that sounds like a lot of work just for one motion. But I know that if you have certain pieces of evidence suppressed, that it could make or break your case. You've mentioned a few things that could be suppressed and why. Can you give us some more examples of the types of evidence that can be suppressed?
Sure. So you said that it sounds like something that could make or break your case. And to kind of stick on the theme of this month of OVIs, the motion to suppress hearing is often the most critical stage of defending an OVI case. That's because it's the place where you challenge the admissibility of the field sobriety tests. You challenge the admissibility of any statements that the accused person may have made during the arrest. You challenge the admissibility of the chemical test, either the blood, breath, or urine test that the government did to determine the person's blood alcohol content. A motion to suppress can also challenge the legality of the stop. So if the officer didn't have a valid reason to pull somebody over, the person didn't actually commit a traffic offense, then the judge can say, well, this wasn't a valid stop. So everything from that point in time forward is excluded from trial. I often describe to clients, especially with OVI cases, that the case is kind of like an onion in that each moment in time is a different layer to the case. So the first moment in time is the officer's decision to pull the person over. The second moment in time is the officer's decision to order the person out of their car. The third moment in time is the demonstration and explanation of the field sobriety tests, then the performance and grading of the sobriety tests. And then we put all of that together to determine, is there probable cause to support an arrest? And if there is, if each of those parts are there, then the government gets to move on to the next part. And then the next part after arrest would be the chemical test. And if they're able to get that into evidence, then we're looking at trial. Can they prove their case beyond a reasonable doubt? Now, they could get to that stage with bits and pieces of their evidence, or in some cases, even very little of that evidence. They can still get to trial and put their issues in front of a jury. But what the court is acting as is a gatekeeper to determine whether the government has broken the rules, cheated basically to get the case to the filing stage, and then in trying to get the case to the trial stage.
Wow, that is really interesting. I'd never thought about it in so many stages like that, and it's really like a game of chess. You have to look at each and everything before you can make your next move, and they don't get to move to trial until they've they've proven that they've done all of those other things the right way. And so that's pretty amazing. What would you say are some of the most common uh, articles that you can suppress?
So items that are seized, anything like contraband, drugs, evidence seized from computers, evidence seized from cell phones is a really hot issue right now, with the government repeatedly trying to break through encryption. That's an invasion of your privacy interest. And if they don't have a warrant to do it, then that invasion is illegal. And the evidence that's gathered as a result of that invasion can be excluded. You can exclude sheets and articles of clothing. You can exclude blood tests. You can really any item of evidence except for a witness's testimony can be excluded from evidence. And then as far as statements go, the accused statements, if they are properly warned according to the Miranda versus Arizona case, you have the right to remain silent. Anything you say can be used against you. Those admonitions and warnings, if they're not given at the proper time, in the proper manner, and ensuring that the accused person actually understands their rights, then those statements can be excluded as well.
Oh, that's really impressive. So I know that, we were talking a lot a couple weeks ago about roadside tests. So, you pointed in very, very great detail all of the different pieces and points just in that one roadside test. And then we've also talked about breathalyzers and how some of those machines aren't calibrated properly, and those results could be thrown out. And this is really where you would have to go to court if there is a piece, and then you would have to have this whole day in court talking about why this one thing needs to be suppressed.
Yeah, that's correct. So the second phase is that hearing. And that hearing is critically important in a variety of cases, not just OVI. The reason that hearing is so important is because the officers have to get on the stand, and they have to give testimony, and they have to present their case and prove that they did their job correctly and fairly, according to the laws of the state and of the United States. I think one quote, I don't want to quote a lot of case law in these, in our interviews, but it's important. One of the earliest cases on suppression that the United States Supreme Court issued said that if the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself, and it invites anarchy. So what the court is doing is saying, this evidence may be reliable. This evidence may prove that somebody committed a crime, but the evidence, the government went about gathering that evidence illegally. And if the evidence is gathered illegally, then we can't allow the government to benefit from that.
Oh, yeah, absolutely. I mean, they have to be held to the highest accountability in order to, go out there and arrest people for breaking the law. You can't have the bad guys, ruling over the bad guys.
Correct. Exactly.
And there's a lot of movie plots about that. But we still fight to make sure that the integrity of the United States is there in all of these cases and present in the courts.
Exactly. and we don't want the government getting away with that. Um, One of the things that I'm very fond of saying, I may not be the United States Supreme Court, but I like to think of myself as somewhat of an authority, is that if we allow the government to get away with the little things, before long, things like the Fourth Amendment, proof beyond a reasonable doubt, the right to counsel become little more than a crack in the sidewalk for the government to step over. And that's supposed to be our shield. You think about where our country started with the British monarchy installing troops and forcing us to house them, imposing taxes without any sort of decision making or input from the colonists, searching people's houses, interrogating them without end until they finally confess due to torture and terrible conditions. The founding fathers said that's no way to run a nation, and that's no way to ensure that your government doesn't become tyrannical. And it's one of the things that I find to be very blessed to live in America, because even today there are countries all over the nation, both first and third world countries, that don't afford these protections to their citizens. And if these protections aren't afforded to citizens, and if we don't respect these protections, then it's only a matter of short period of time before the government is quartering troops in your home again. I'll tell you what, Erica, I don't want some smelly soldier from some foreign invading country living in my basement.
Yeah, no, that sounds awful. But you're absolutely right. It's really scary, and I don't think a lot of people appreciate what people. It's hard to even imagine what that's like living where we live today. But it happens all over the world, and in fact, we even try to help some of those countries that are having those problems, and with there being no support, their citizens being killed in the street by the government. It just there's a lot of things that just as humans we want to make sure don't happen. And it all starts with these tiny little cracks in the system, like you said. And I love that you look at you probably have a checklist that you go through, because every single case, I mean, maybe that's making it a little simple, but I mean, every single case, you have certain things that you have to look for, and you probably see them all the time. And so, I mean, I don't know, you don't have a checklist, but I know that you do this all the time.
Well, having done it for 13 years, I can pretty readily identify the issues that I know are going to be fruitful by reading discovery, police reports, witness statements, things of that nature. But I absolutely do have a checklist, because I want to make sure that each of those items is checked off. You commented on countries that are currently violating their clients' rights, or I'm sorry, their citizens' rights. And you can look no further than the coronavirus that is spreading through China right now. And there's an article that was published, I saw it just today, that one of the reasons this illness is spreading so fast is because when the citizens of the town where it started reporting it and started going and petitioning their government for assistance with it, they weren't given medical treatment. They were arrested and interrogated and basically said, look, you're not following the party line. And if you're not following the party line, you're not a good communist, and therefore you're going to be punished. This is an example. People often say to me, how can you try to get somebody who's guilty out of trouble? How can you try and exclude evidence that proves their guilt when you know that it's going to cause a guilty person to go free? Well, we're living in that right now, Erica. We are living in a situation where illegally suppressed rights have now resulted in what very well could be a worldwide crisis. And that's the reason these rights are so important. Government should be beholden to the people. The people are not beholden to the government.
Well, I couldn't agree with you more. And I really think that, the work that you do with making sure that each and every one of your clients, it's not like you're trying to have guilty people go free, but you're making sure that the rules are followed and that, that everybody is treated fairly in the situation. Now, these motions to suppress are key in your cases. And I guess, can you give us some examples of how this can benefit your clients?
Sure. So, keeping with the theme of the month, let's go back to OVIs. So, with the OVI in particular, what we're looking at is, was there a valid reason to stop the driver? Was there a valid reason to pull him out of the car? Were the tests performed properly, both the field sobriety and the chemical analysis? If the officer didn't have that good reason to pull my client over, and I can identify that reason and convince the judge that the officer's reason wasn't good enough, then every item of evidence that the officer seized after that point is now tainted and not admissible. So it can result in all of the evidence against my client being excluded, which essentially should result in a dismissal. I can tell you right now, Erica, that I've got a case where the government has very little evidence. We had a motion filed, we had a hearing on the motion, and the state failed to demonstrate that the evidence they gathered was gathered legally. And so the judge excluded vast amounts of their evidence. And so they're going to go to trial next week. They have not made an offer that's reasonable. So they're going to go to trial next week based on what is essentially an odor of alcohol and a traffic accident. And that's it. A jury could find my client guilty. Juries absolutely have independence and they can view the evidence and make their decision. I would say that there's nowhere near enough evidence to survive even a motion to dismiss at the conclusion of the state's presentation, but we'll see. We'll talk about it next week.
Well, I can't wait to hear it. It's like a cliffhanger here.
Tune in next week.
I know, it's going to be great. So is there anything else that you'd like to add about motions to suppress? I mean, I think it's something that isn't really talked about if you're not a lawyer, like just among the lay people. Nobody really talks about motions to suppress. It's not a big thing, but it obviously is a hinge that really can make or break a case. If there's any other information you want to share about that or any other stories, we'd be glad to hear them.
For sure. So, and again, sticking with the common themes that I want to establish with these interviews in educating people. Mm-hmm. When you're talking to a lawyer, if you've been accused of a crime and you're interviewing lawyers, which you absolutely should interview your lawyer, as much as that consultation is a determination of the lawyer's desire to take on your case, capacity, do they have enough caseload availability to take on your case? That is also your opportunity to decide if that's the right lawyer for you. And you should ask, what suppression issues do you see in my case? How would you go about determining whether the evidence was validly seized and gathered in this case? And if your lawyer isn't able to talk about that, if your lawyer shies away from filing motions, really consider whether that lawyer has the skill set necessary to represent you in your criminal case. Because the motion to suppress is a critical tool in the criminal defense lawyer's toolbox. And if it's not used properly, and if it's not used frequently, it just rusts away and the client's rights go with it.
Well, write that down, folks. If anything ever does happen where you need a criminal attorney, you really need to ask about the cracks in the case that can be suppressed. And, a lot of attorneys will just assume that you don't know this information and they may gloss over things. But just like anything else, you've got to inspect what you expect. And if you want to get the best performance out of your attorney and pick the best attorney, you need to know the right questions to ask. And every week, Brian has so graciously given us the cheat notes on how to hire the best person. Um, so so keep that in mind. And so, but if you do need a good attorney, I would absolutely highly recommend attorney Brian Jones, because he has all this inside information. He's in court every single day, and he is defending the rights of his clients, and finding the cracks in the case so that you can make these things a lot shorter, and you can have a much better outcome.
Absolutely. Thanks, Erica.
Thank you so much. Really appreciate speaking with you today. And I wish you luck on the case next week. We can't wait to hear what happens.
Thank you. Take care. Have a good weekend.
Take care, you too.
Bye.
Bye bye.